Hi, it's your partner again in Criminology Reviews. How have you been? Were you still following our page? If not, please support and subscribe, then click the notification bell for more criminology-related contents. Thank you. And now, we will proceed on our discussion. Today, we will be discussing Title 2 of Book 2 upon the humble request of one of our followers. Title 2 Crimes Against the Fundamental Laws of the State. Chapter 1 Arbitrary Detention or Expulsion, Violation of Dwelling, Prohibition, Interruption, and Dissolution of Peaceful Meetings and Crimes Against Religious Worship. Now, let us talk first about Section 1, Arbitrary Detention and Expulsion. Article 124, Arbitrary Detention. Any one public officer or employee who, 2. Without legal grounds, 3. Detains a person. 1. Commission of a crime, or 2. Violent insanity, or 3. Any other ailment requiring the compulsory confinement of the patient in a hospital shall be considered legal grounds for the detention of any person. When you say fundamental laws of the state, it is the Constitution, because the Constitution is the highest law of the land. So the acts punished under Title 2 are acts in violation of the Bill of Rights inscribed in our Constitution. The first among these is arbitrary detention. Let us first understand the 3 kinds of arbitrary detention. 1. Arbitrary detention by detaining a person without legal ground under Article 124. 2. Arbitrary detention by failing to deliver the detained person to the proper judicial authorities within 12, 18, 36 hours under Article 125. 3. Arbitrary detention by delaying the release of prisoners despite the judicial or executive order to do so under Article 126. Now, let us understand the elements of arbitrary detention under Article 124. 1. Arbitrary detention is committed by any public officer or employee. 2. Offender detains a person. 3. Detention is without a valid ground. Under Article 124, arbitrary detention is committed by any public officer or employee. The second element requires that the offender detains a person, and the third element that detention is without a valid ground. Valid grounds for detention. 1. Detention is by virtue of a warrant of arrest. 2. If the detention is based on the circumstances of a valid warrantless arrest. 3. If a person is suffering from violent insanity or any other ailment requiring compulsory confinement. A driver entered a one-way street. Despite the sign in the street that entry is prohibited, he entered the street, and a traffic enforcer arrested him, placed him behind bars. That was in the morning. The police left. He came back in the afternoon and released the said person. Is the police officer liable for the crime of arbitrary detention? Yes, the police officer is liable for arbitrary detention. He is a public officer vested with authority to effect arrest. He detains a driver. The detention is without legal ground. Having violated LTO rules and regulations is not a valid ground for incarceration or being placed behind bar. Under the LTO rules and regulations, he must only be given a ticket, but that is not sufficient for him to be placed behind bars. Hence, the incarceration is without valid ground. The police officer is liable of arbitrary detention. The obvious intent is to detain him. I hope you're still following. That is all to remember about Article 124. Now next will be Article 125. Article 125. Delay in the delivery of detained persons to the proper judicial authorities. The penalties provided in the next preceding article shall be imposed upon the 1 public officer or employee, who 2 shall detain any person for some legal ground, and 3 shall fail to deliver such person to the proper judicial authorities within the period of 1. 12 hours, for crimes or offences punishable by light penalties, or their equivalent. 2. 18 hours, for crimes or offences punishable by correctional penalties, or their equivalent. And 3. 36 hours, for crimes or offences punishable by afflictive or capital penalties, or their equivalent. In every case, the person detained 1 shall be informed of the cause of his detention, and 2 shall be allowed upon his request to communicate and confer at any time with his attorney or counsel. Elements of arbitrary detention under Article 125. 1. The offender is a public officer or employee. 2. He detains a person for some legal ground. 3. the said public officer fails to deliver the detained person to the proper judicial authorities within 12 hours for the crime punishable by light felonies or their equivalent, 18 hours for crimes punishable by correctional penalties or their equivalent, 36 hours for crimes punishable by afflictive penalties or their equivalent again. The offender is a public officer or employee vested with authority to effect arrest and detains a person. The second element requires that the offender arrest and detains a person for some legal ground. Let us analyze this example. The police officers were conducting a patrol and they saw X in the act of stabbing Y, and so they arrested X, placed him behind bars. That was Friday evening. The following day, Saturday, they could not file a case, courts are closed. Sunday, courts are also closed. Monday was declared a special non-working holiday, courts are closed, so the arresting police officers filed the case Tuesday, only 8 o'clock in the morning. Are the police officers liable for arbitrary detention under Article 125? The answer would be no. The filing of the case, the delivery was made beyond 36 hours under Article 125. The police officers are not liable under Article 125. The Department of Justice has issued an administrative circular interpreting 12-18-36 hours. These 12-18-36 hours refers to working hours. It refers only to time that courts are open to receive the complaint or information. So whenever the courts are closed to receive the complaint filed against them, you do not include that to the 12, 18, and 36 hours. I hope you are still following. And now let us move to the next article. Article 126, Delaying Release. Article 126, Delaying Release. The penalties provided for in Article 124 shall be imposed upon any public officer or employee. 1. Who delays for the period of time specified therein. 1. The performance of any judicial or executive order. 2. For the release of a prisoner or detention prisoner. 2. Or unduly delays. 2. 1. The service of the notice of such order to said prisoner or 2. The proceedings upon any petition for the liberation of such person. Let us talk about the elements of delaying release. 1. Offender is a public officer or employee. 2. There is a judicial or executive order for the release of the prisoner or detention prisoner, or that there is a proceeding upon a petition for the liberation of such person. 3. Offender unduly delays the A. Service of notice of such order to the prisoner. B. Performance of such judicial or executive order for the release of the prisoner. C. Proceedings upon the petition for the release of such prisoner. The crime will only arise when the said public officer or employee, without valid reason, delays the performance of the judicial or executive order for the release of a prisoner. Therefore, if the said public officer has a reason for such non-performance to the said judicial order, he cannot be held liable. Example of an executive order issued for the release of a prisoner. After a preliminary investigation, the fiscal finds no probable cause against the accused, and the fiscal will order the release of the said prisoner. Failure of the jail warden to do so will make them criminally liable under Article 126. The next article is about expulsion. Art. 127. Expulsion. The penalty of prison correctional shall be imposed upon any public officer or employee who, not being thereunto authorized by law. 1. Shall expel any person from the Philippine Islands, or 2. Shall compel such person to change his residence. Expulsion is committed by any public officer or employee who expels any person from the Philippines or compels a person to change residence when in fact he is not authorized by law to do so. Now the elements of expulsion. 1. Offender is a public officer or employee. 2. He either A. Expels any person from the Philippines. B. Compels a person to change residence. 3. Offender is not authorized to do so by law. Persons given the authority to expel a person from the Philippines or compel a person to change his address. 1. President, who has the inherent deportation power. He can deport a person from the Philippines to another country. 2. A judge can compel a person to change his residence. For example, a person who is convicted of a crime wherein the penalty imposed upon him is destero, where the convict is prohibited from entering a place entered in the judgment of the court. That is everything about Section 1 of Title 2 Crime Against the Fundamental Laws of the State. Hi once again. This is your Criminology Review partner. I really hope this channel is helping you even in the smallest possible way. If so, please support by sharing and watching the full video on our YouTube channel. Thanks. Until next time.